I have watched unanimity expose vulnerability before, not through compromise, not through moderation, through 9 justices agreeing that the legal foundation beneath a regulation never existed. The Supreme Court issued a unanimous decision in early 2025 that most media outlets described as narrow, a technical ruling about standing and procedural questions. But embedded within that unanimous opinion was a reaffirmation of the historical tradition test established in Bruin. And that reaffirmation just destabilized magazine capacity restrictions in 11 states, representing 107 million Americans. 9 states currently limit magazine capacity to between 10 and 15 rounds. California, Colorado, Connecticut, Hawaii, Maryland, Massachusetts, New Jersey, New York, and Vermont all maintain these restrictions. The District of Columbia and Rhode Island recently joined this group. These laws share identical logic. By forcing shooters to reload more frequently, capacity limits reduce casualties in mass shooting scenarios. If a magazine holds fewer rounds, an attacker must pause to reload, creating opportunities for victims to escape or bystanders to intervene. But capacity limits face a problem that unanimous Supreme Court decisions make impossible to ignore. There is no historical tradition in America of restricting the capacity of arms that citizens could own. When the Second Amendment was ratified in 1791, the founding generation did not restrict the capacity of existing arms. The Girandoni air rifle held 22 rounds and was used by the Lewis and Clark expedition. Pepperbox revolvers held multiple charges. High-capacity firearms for that era existed, and there is no evidence of colonial or early American laws limiting how many rounds they could fire. The unanimous decision did not address magazine capacity directly. It concerned a challenge to Illinois' assault weapon ban and the question of whether plaintiffs had proper standing to sue. But Justice Barrett, writing for a unanimous court, repeatedly emphasized that firearms regulations must be evaluated under the historical tradition framework. She cited Bruin 6 times. She quoted the requirement that governments identify well-established and representative historical analogs. She noted that modern concerns about public safety do not override constitutional analysis rooted in founding-era understandings. That emphasis matters because magazine capacity limits have been defended almost entirely through modern policy arguments. State attorneys generally cite studies on mass shooting lethality. They reference FBI data on round counts fired in active shooter incidents. They argue that capacity limits represent reasonable regulations that preserve Second Amendment rights while reducing harm. But none of those arguments address the historical question that Bruin and this unanimous decision require courts to answer. Federal judges in multiple circuits have been holding magazine capacity cases in abeyance since Bruin was decided in 2022. They were waiting for additional guidance from the Supreme Court on how strictly to apply the historical tradition test. This unanimous decision provides that guidance. It confirms that the test is mandatory, not discretionary. It affirms that all 9 justices agree that historical tradition governs. California's 10-round limit has been challenged in Duncan v. Bonta since 2017. The case has bounced between district court and the Ninth Circuit multiple times. In 2019, the district judge struck down the limit. The Ninth Circuit reversed. After Bruin, the case was remanded with instructions to reconsider under the new framework. As of February 2025, the district court has scheduled new hearings to evaluate whether California can identify historical precedent for capacity restrictions. New Jersey reduced its magazine limit from 15 to 10 in 2018. The Association of New Jersey Rifle and Pistol Clubs immediately filed suit. That case has been in litigation for 7 years. After Bruin, the Third Circuit remanded for reconsideration. Oral arguments held in late 2024 revealed significant judicial skepticism about the state's ability to demonstrate historical precedent. Colorado's 15-round limit was passed in 2013. A new lawsuit filed in 2024 directly applies the Bruin framework. According to court filings reviewed in early 2025, the state has identified no founding-era or Reconstruction-era laws limiting magazine capacity. Maryland's limit has been challenged in multiple cases, consolidated under Association of New Jersey Rifle and Pistol Clubs versus Bruck. After the unanimous Supreme Court decision reaffirming the historical tradition test, plaintiffs filed an emergency motion asking the Fourth Circuit to expedite review. The court granted that motion, and oral arguments are scheduled for mid-2025. The pattern across all these cases is identical. States defend capacity limits by arguing that they serve compelling public safety interests. They cite expert testimony about mass shooting dynamics. They reference legislative findings about the dangers of high-capacity magazines. They argue that 10 or 15 rounds is sufficient for self-defense, so the restrictions do not substantially burden Second Amendment rights. But none of those defenses address the threshold question that the unanimous Supreme Court decision reinforces. Where is the historical tradition? State attorneys general have attempted several historical arguments. Some point to founding-era regulations that prohibited storing large quantities of gunpowder in urban areas. They argue this shows a tradition of limiting dangerous quantities. But those regulations addressed fire hazard risks, not restrictions on individual arms. They limited storage, not capacity. Other states reference Reconstruction-era laws that prohibited carrying multiple weapons. A Texas statute from 1871 made it illegal to carry more than one pistol at a time. States argue these restrictions show a tradition of limiting firepower. But those laws regulated carrying multiple separate firearms, not the capacity of a single magazine. A person carrying 2 6-shot revolvers in 1871 had 12 rounds available, exceeding the 10-round limits several states currently impose. Some states have cited 20th century restrictions on Tommy guns and sawed-off shotguns as evidence that capacity can be regulated. But those regulations were enacted in the 1930s, over a century after the founding era. The Supreme Court has repeatedly stated that the relevant historical period is the founding era and Reconstruction. 20th century regulations do not constitute founding era tradition. The strongest argument states have made is that the founding generation understood that arms regulations could evolve as technology changed. They cite Heller's statement that the Second Amendment protects arms in common use, arguing that the founders anticipated future developments and expected regulations to adapt. But the unanimous Supreme Court decision forecloses this argument by emphasizing that historical tradition, not judicial policy judgments, determines the scope of the right. If the founding generation did not restrict capacity when multi-shot weapons existed, the fact that modern magazines hold more rounds does not create authority to impose limits that lack historical precedent. Standard capacity magazines are ubiquitous. Law enforcement estimates place the number of magazines capable of holding more than 10 rounds at over 100 million units in civilian hands. A Glock 17, one of the most common handguns in America, ships with a 17-round magazine. An AR-15 typically comes with a 30-round magazine. Restricting citizens to 10 rounds means prohibiting the standard configuration of firearms that millions of Americans own. The common use standard from Heller becomes critical here. If over 100 million standard capacity magazines exist in civilian hands, and if they are used overwhelmingly for lawful purposes, including self-defense, sport shooting, and hunting, then they are arms in common use. The Supreme Court has stated that arms in common use cannot be banned. Magazine capacity limits do not ban the magazines outright in most states. They ban future sales and possession, grandfathering existing magazines in some cases, but the constitutional analysis is the same. If the arm is in common use for lawful purposes, restrictions on that arm must be rooted in historical tradition. States have argued that 10 rounds is sufficient for self-defense, so capacity limits do not substantially burden the Second Amendment. But that argument assumes that courts can judge how much of a constitutional right is enough. The Supreme Court rejected that approach in Bruin. The opinion explicitly stated that courts should not conduct means-end scrutiny or balance the importance of a right against government interests. The question is not whether 10 rounds is sufficient. The question is whether there is historical precedent for the government dictating what is sufficient. The unanimous nature of the recent decision matters immensely for this issue. When all 9 justices agree that historical tradition governs, lower courts have no room to avoid the analysis. Before this decision, some judges were attempting to read Bruin narrowly, treating it as applying only to concealed carry licensing. The unanimous reaffirmation forecloses that interpretation. The historical tradition test applies to all firearms regulations. Magazine capacity limits must meet that test or fail. The timeline for challenges is accelerating. In 2023, there were 4 active federal cases challenging magazine capacity limits. As of February 2025, there are 11. Second Amendment organizations have recognized that the unanimous Supreme Court decision creates an opportunity to force the historical tradition analysis in multiple circuits simultaneously. If one circuit conducts a thorough historical review and concludes that no tradition supports capacity limits, other circuits face the same analysis with the same historical record. Gun control organizations understand the threat. Everytown for Gun Safety published a legal memorandum in late 2024 urging courts to find analogical reasoning in founding-era regulations of dangerous weapons. They argue that restrictions on concealed daggers, spring guns, and other unusual arms show that the founding generation understood firearm dangers could be addressed through categorical regulations. But those examples involve weapons considered outside the scope of legitimate self-defense, not limitations on the capacity of common arms used for lawful purposes. The political response to potential judicial invalidation of capacity limits is already forming. California's legislature introduced a bill in early 2025 that would ban all semi-automatic firearms if the magazine capacity limit is struck down. New Jersey's Attorney General issued a statement warning that the state would defend its 10-round limit vigorously and explore all available legal strategies. But states cannot create a historical tradition that does not exist. The economic impact of striking down capacity limits would be significant. Manufacturers currently produce separate product lines for restricted states, offering 10-round magazines for California-compliant models and standard capacity magazines for free states. If restrictions fall, the dual production becomes unnecessary. But manufacturers would face liability questions. If a standard capacity magazine sold legally after restrictions are lifted is used in a crime, do manufacturers face lawsuits? States have already indicated they will pursue litigation strategies that hold the industry accountable, even if capacity limits are struck down on constitutional grounds. Enforcement complications would be immediate. California has required registration of high-capacity magazines possessed legally before the ban took effect. If the ban is invalidated, does that registration data remain in government hands? Can it be used for other purposes? Do individuals who complied with registration requirements have causes of action against the state for compelling them to identify their property under a law later deemed unconstitutional? These questions have no clear answers. What the unanimous Supreme Court decision accomplished was not the immediate invalidation of magazine capacity limits. What it accomplished was the elimination of any remaining argument that the historical tradition test is negotiable. 9 justices agreed. Across every ideological division, across every jurisprudential approach, the court spoke with one voice. Historical tradition governs. And when that standard applies to magazine capacity limits, those limits have no foundation. I have seen this before. Not the sudden collapse of a law, but the removal of the ground it stood on. The capacity limits in 11 states are not falling today. They are falling slowly through the methodical application of a test they cannot satisfy. The historical record contains no precedent for what these states are attempting, and a unanimous Supreme Court has confirmed that without that precedent, the restrictions cannot stand. What remains is time. Time for cases to work through districts and circuits. Time for judges to conduct the historical analysis that will reach the same conclusion in California, New Jersey, Colorado, Maryland, and every other jurisdiction that tried to limit what the founding generation never restricted. Time for legal frameworks built on modern policy preferences to discover they have nothing beneath them. And when structures have nothing beneath them, they do not stand, they wait to fall.